Good morning. The 14B District Court is now in session. My name is Elaine Washington, and I'm the judge that will be presiding over this session. The court will call the case of, well, first of all, everyone on the call should remain muted until their case is called. When your case is called, please allow the attorneys to place their appearance on the record first, and then after that, please state your name. The court will call the case of the State of Michigan versus Kelly White, case number 23S00372.
Good morning.
Good morning.
Good morning, Judge Washington. Raymond Burkett on behalf of Ms. White, who is incarcerated at the time.
Good morning, Mr. Burkett. Ms. Kelly
How are you?
White, get someone to unmute your device and state your name.
Kelly White.
Thank
Good
you. All right, we're here in this particular matter today for a bond violation and pretrial.
Yes, Your Honor.
Ms. White was arraigned before the magistrate because she had another bond violation allegation of her tether, her SCRAM tether. It indicates that there was a tamper was detected of her SCRAM bracelet and lasted from December 31st of 2023 at 5:26 a.m. until 9:35 a.m. 4 hours and 9 minutes. Alcohol was detected during the tamper. Then on December 31st from 3:49 p.m., a tamper was detected that lasted until January 1st from 3:49 p.m. until 8:57 a.m. the next day on New Year's Eve. Then on January 6th at 6:59 a.m., a tamper was detected by the SCRAM tether that lasted until January 7th at 8:59 a.m. for a total of 1 day, 2 hours, and 0 minutes. Alcohol was detected. And then January 8th from 6:12 p.m. to January 9th at 4:49 p.m. for a total of 22 hours and 37 minutes. Alcohol was once again detected. And then on January 10th from 5:58 p.m. To January 11th at 11:40 a.m. for a total of 17 hours and 42 minutes, alcohol was once again detected. Your client has a right to have a hearing on these matters, at which time, if it is shown that she actually did commit these violations, her bond would be revoked, which it already been. Well, actually, at this point, she has a $50,000 cash assurity. It hasn't been totally revoked. What would your client like to do?
Well, first of all, Your Honor, I would like to prepare a defense for this. I just really got all this information and did a substitution of attorney. I was not aware of all those tampering, but I do know that she's gone to correctional services a bunch of times complaining that the thing was too tight and was too loose on her. I read where they have a number of occasions kept adjusting it. In terms of the alcohol, now she denies using any alcohol during this period of time.
Sounds like you're saying she wants a hearing.
I'm sorry, I couldn't hear you.
It sounds like you're saying that she wants a hearing.
Well, first, I would like to address the issue of bond. $50,000, Your Honor. I mean, this woman is a working nurse with a child to take care of. There's no way she can make that kind of a bond. She has virtually no money whatsoever. And I think that we can resolve this case personally, but because I don't think this was an intentional tampering with.
Are you aware that this is her third SoberLink violation?
I was aware once I received the discovery, yes.
Oh, okay, all right.
Yes. But I still think this can be resolved. But right now I'm asking you, don't keep her in jail on a $50,000 bond. and I was gonna ask for a bond hearing and a date to report back where I can sit down with her and go over all the materials.
Ms. McDuffie?
I'm going to try to put all of this in a really quick nutshell. I know that Mr. Burkett is new to the case and catching up on Ms. White's history. Ms. White actually has more violations than just 3. We started out at her very first pretrial with 2 ETG positives already at that point, before she even got to that first pretrial. Ms. White was warned way back that she was going to get bond potentially revoked, and she's continued. She is struggling. We know that. She just can't stop drinking. And Mr. Burkett, we can catch up offline about the full extent of what's been going on in this case. So she's in custody now, not for her own safety, I think, and of course, safety of everybody else. And with respect to bond, I would ask that bond continue for that reason, unless she is released to inpatient treatment, which I think she needed, a while ago, but I don't know that her previous attorneys were able to facilitate that for her. With respect to the pretrial status, Ms. White, again, all the way back in August, I recommended or suggested at least that she get referred and screened for either our court's recovery court or the 15th District Sobriety Court. I don't think anything has ever happened with that because we have, not your fault, Mr. Burkett, we have been adjourning for assessments that aren't going to make any difference. And I don't know that she's been referred, if she's on anybody's waiting list for treatment at all. So the case, there aren't going to be any offers on the underlying case. My concern is that she get into some treatment ASAP. And so that's my request in terms of bond, that it continue with a release to treatment. And Mr. Burkett, I don't mind adjourning. I also want to fill Mr. Burkett in on how things go when we have hearings in this court regarding SCRAM tether tampers and violations with or without alcohol, and what that actually is going to mean for Ms. White. So with that being said, I would ask that the court continue bond with a release to treatment, and we can adjourn for a final pretrial so Mr. Burkett can catch up on the case.
Thank you.
Let me repeat, Your Honor, I had no idea of the history that the prosecutor just told you about. I would have advised Ms. White, had I been the attorney and she was offered a chance to go to sobriety court and get help. My advice to her, jump on that with both legs and to do that. But Your Honor, $50,000 bond, that's what we charge murderers and rapists with. We don't charge a person tampering with a device, a $50,000 bond. To me, that's a constitutional violation. I'm going to recommend to her that she does get medical help and check into a facility. When I talked to her, I told her I was going to see if Don's firm would take her, but right now they're kind of backed up with help, but we intend to apply there for help, because I agree, based on what the prosecutor just told me, she definitely needs some type of medical help. But I still don't want her. She has a job. She's got a son to take care of, and I'm asking for a reasonable, some type of a reasonable bond.
Anything further, Mr. Burkett?
No, I think I talked enough.
All right. Well, the reality is you can think it's constitutional, unconstitutional, however you want to think about it. You have an appeal right for that. At this point in time, I'm the person who set the bond at $50,000 cash security because I think that it is the appropriate amount. We've been dealing with Ms. White and her violating all of her sober link, then SCRAM on numerous occasions. This is a operating while intoxicated, while a second offense. And the reality is that she's a danger to society and she cannot get it together right now. So I have to protect her from the community, and that is the thing that I'm looking at. And partially I have to protect her from herself. So you're entitled to have your hearing on that. But at this point in time, this bond is not going to change. It will remain $50,000 cash or surety, or she can be released to treatment. Those are her options.
Thank you.
And what she should have done a long time ago, when I talked to her starting back in August about my concerns about her issues of drinking, is she should have gotten herself into some treatment at that point. When she came back to me on August, so the first one was August 1st, then she came back to me on August the 29th, and we talked about her drinking and her sober link issue. Then she came back to me again. Well, she got another a bench warrant in December, and we then ordered her onto SCRAM in December. And then at that point in time, she continued to drink, and then she got this additional violation. She should have thought about those things.
Your Honor, I did not continue to drink. I apologize. I work and I use hand
You
sanitizer
really need to be quiet.
all the time.
Ms. White, don't interrupt me again.
I'm sorry, Your Honor.
So she's entitled to have her hearing, and I can give that to you as quickly as you would like. When would you like to have your hearing, Mr. Burkett?
I would like you to give me another date to come back, not necessarily for a hearing, but for a pretrial so we can make some decisions. Please don't say the 22nd because I'm in trial that day.
That one doesn't work?
No, ma'am. Any day after that should be okay.
You're in trial on the 20th as well?
Yeah, that whole week I'm really kind of jammed up. I'm sorry.
That's okay.
But the following week after that, I'm okay.
How about the February 26th?
That will be fine. And in the meantime, I'm going to, consistent with your order, try to get her into an inpatient treating center.
I'll also place on the order that she can be released to treatment. That way they can assess her now and get her in a position to get ready to go to treatment.
Those will be my plans, Your Honor.
All right. So we'll see you back here on December 26th. If you are requesting that we have a hearing, which she's basically indicating that she wants, because she's claiming she used hand sanitizer. We need to let Ms. McDuffie know so she can have the witnesses present. We'll have Mr. Hayes here from the SCRAM company, as well as the person from Community Corrections, Mr. Levitt.
Okay, we'll do.
All right. Thank you.
No, thank you.
It'll be at 11 o'clock a.m.
I think that's gonna be at 9 o'clock.
No, I said 11.
Beg your pardon?
I said 11 a.m.
Oh, 11?
Yes.
Okay. Thank you again.
You're welcome. State of Michigan versus Jonathan Freeze, case number 23S00223.
Yes, ma'am. That's me.
Good morning, Your Honor. For the people.
Good morning, Your Honor. Good morning, my lawyers.
Good morning, Your Honor. Assistant Public Defender Donovan Lee before Mr. Freeze, who has stated his day.
Thank you. Good morning, Mr. Freeze.
Good morning. How are you?
I'm pretty good, sir.
Good.
All right. We're here for a pretrial in this matter.
Your Honor, with regard to the pretrial, I'd request an adjourned pretrial date as I had some difficulty getting hold of Mr. Freeze, which has now been resolved, and I'd like to be able to talk to him further before I decide how to proceed in this matter.
I guess we're here for a pretrial and a bond violation. He was arraigned by the magistrate on February 5th on the bond violation.
Yes, Your Honor, we'll be pleading guilty of that violation.
All right, Mr. Freeze, the
Yes, ma'am.
bond, the violation alleges that essentially you did not go to any of your testing.
Yeah. I was in the impression, which I just got situated now, that I go to outpatient treatment. I go to the methadone clinic daily, every day but Sunday, and I was actually pulled over on Saturday because you got by law in the state of Michigan, you got to bring a lockbox during your Sunday dose home.
Mr. Freeze, could I stop you for a minute?
Yeah.
The judge is simply going to be asking you whether or not you're going to admit that you weren't testing.
So, what should I say? Yes?
Well, you weren't testing.
I
Mr.
was
Lebo,
testing, but I was
Mr.
testing at
Lebo,
therapeutics. For some reason, they weren't getting sent over. Okay,
Mr.
what am I looking
Mr.
at?
Freeze, Mr.
Yes.
Freeze, one moment, please. Mr. Lebo, I think you're gonna need some additional time to talk to him and go over.
No,
process.
I'm good, I'm good. I wasn't testing, I'm sorry.
Mr. Freeze, please don't interrupt me, okay? And you're asking for an adjournment anyway, so I think he needs to fully understand how this process works.
I do, I was
I agree,
mistaken,
Your Honor.
ma'am. I was not testing, I'm sorry.
Mr. Freeze, just could you please stop talking for a moment and let the judge talk?
Mr. Freeze,
Yes, ma'am.
try this one more time. If you don't get it right, we're adjourning this, okay?
Yes, ma'am.
You have a right to have a hearing on this bond violation, at which time, if you are found guilty or if you admit to being guilty, you could have your bond revoked. Do you understand that part, sir?
I do.
All right. Understanding that, are you waiving your right to have a hearing in this matter?
Yes, ma'am.
All right. And you're acknowledging that you failed to go to community corrections and test.
Yes,
Please
ma'am, I am.
raise your right hand. You swear affirm the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, I do.
You may lower your hand. So you missed tests on March 20th, March 27th, April 4th, and April 14th at community corrections, correct?
Correct, ma'am.
All right, thank you. I find that there is a knowing and willing admission to the violation. Are you satisfied, Ms. McDuffie?
Yes, Your
Yes.
Honor.
Likewise, Your Honor.
Thank you. And now he fully understands that he meets the test at community corrections?
Absolutely,
ma'am.
Your Honor. And my understanding that you have been testing there since his release.
Yeah, I just dropped this morning.
All right, great. All right. Understanding that and your request for a adjournment, we'll adjourn this matter to March 12th at 9:00 a.m. Does that work with everybody's calendar?
So I got another court date at March 12th
Yes, sir. At 9
at,
a.m.
is it over Zoom or
Yes, it's over Zoom still. sir.
March 12th at what time?
9 a.m.
March, RCH, sorry, just bear with me, 12th. At 9 a.m. Okay,
Okay.
9 a.m. you said, right?
Yes, I did.
Okay, thank you so much, ma'am. Sorry for the confusion.
That's okay. We'll see you then, okay?
Okay, I will be here at 9 a.m.
All right, bye-bye.
Thank you, bye-bye. Thanks, my lawyer.
Thank you, Your Honor. Mr. Freeze,
Am
I'll
I
be.
free to go?
You can go now. Yes, have a good
Thank you
day.
so much. Have a great day. Bye-bye.
Bye-bye.